Free will is not a criterion in law. Full stop. The prosecution never has to prove that the defendant had free will, and the defendant never has to establish that he didn't have free will.
Now the moral responsibility is get weakened, but still the criminal system is very strong.
I think that's just entirely wrong.
And he says these are questions about free will. But I want to be sure that I understand you well. I think you are making the exact same criteria, but for competence, not free will.
No.
All right?
No, that's not right.
Welcome to Hoshivar Podcast. My guest today is Professor Stephen J. Morse, one of the most respected legal philosophers and scholars in the emerging field of neurolaw. He holds dual appointments in law and psychiatry at the University of Pennsylvania, where he has become a leading voice in debates about intersection of law, neuroscience, and moral responsibility. Professor Morse has consistently argued that criminal law should be based on intentional action, not neural mechanisms alone. While acknowledging that neuroscience may provide valuable insights into human behavior, he defends the compatibilist and folk psychological approach to legal responsibility. In his view, the law rightly treats people as intentional agents, not as mere biological machines. In contrast to both free will skeptics, who view neuroscience as undermining responsibility, and naturalistic libertarians who insist on indeterminism or freedom, Professor Morse maintains that compatibilism offers the most coherent and pragmatic framework for the law. He has also been critical of what he calls brain overclaim syndrome, the tendency to infer more from neuroscience than the data warrants, especially in the courtroom context. Today, we will explore his legal philosophy in relation to broader metaphysical debates on free will and ask how he navigates issues like addiction, mental illness, punishment, and the limits of moral responsibility in a deterministic framework. Professor Stephen J. Morse, welcome to the show.
Thank you very much, Dr. Shafa, and thank you for the most accurate summary I've ever heard of my views.
Thank you so much. Thanks to AI, these days AI gives a brief introduction to my guests. I get help from the AI. Anyway, thank you. I start, my first question is a general question, but we would like to hear about that. What is the neurolaw? For some of the audience or the viewers of this, still the neurolaw is a term that is new to them. What subjects are studied in neurolaw?
Well, most generally, the topic of neurolaw is what insights from neuroscience, and it's mostly behavioral neuroscience, social, affective, and cognitive, because the law is about behavior. The law is not about neurons. So the question is, what insights from behavioral neuroscience can inform the law at the level of individual case making, decision making, legislation, and legal policy more generally? And there are, I would say, three camps of people who are interested in the topic. I think the largest believe that neuroscience has, at present, a lot to add. Probably the smallest are people who think it has absolutely nothing to add, because it's a category mistake to think that what we learn about the brain or the nervous system will bear on acting human agents. And then there's the group I consider myself part of, which is that neuroscience is likely to make modest contributions to the law as it is, but it's not going to radically cause a major change of any sort in our legal system, not at present, and from my point of view, not any time in the foreseeable future.
Thank you. Because of what you mentioned, something came to my mind that I wanted to ask later. So because of the combat or interaction of neuroscience with law, I asked this question from Sapolsky and also from Sapolsky and Professor Caruso. They had their own answer. But what do you think is the most stronger part here? The neuroscience is strong enough right now to affect the law, or the changes in the law happens through intuition of the public? So I mean, the neuroscience is getting stronger right now based on the findings, but as I heard from you, it's not affecting law in the direct way for now, at least what we see now. But what you see in the next decade or so, if the neuroscience gets stronger, it can change the law directly, like lawyers or judges, or if these changes go through the intuition or public change. Because
I don't have a crystal ball, so it's very hard for me to predict what the future is going to bring. But what I can say is, at least in the United States today, the only area in which neuroscience, and by that I mean essentially neuroimaging, has had an effect on cases, not on legal policy generally, but on cases, is in the death penalty area. There's one other I'll get to in a second. The bar for admitting scientific or technical evidence at sentencing proceedings, especially death sentencing proceedings, when so much is at stake, the bar is very low. So advocates, and it's typically advocates for the defendant, don't have to make much of a showing about the scientific validity or legal relevance of the imaging they wish to use on behalf of the convicted person who's facing potential death. I'm not sure how much difference it's made in how many cases, but there is an area where a death penalty advocate who's defending somebody in a death penalty proceeding would be well advised to ask the judge to order a scan if there's any reason whatsoever to believe that there might be brain damage or some kind of lesion that could be identified on a scan. Now, the problem with that is, let's assume you find something. Does that mean the defendant is in any way less responsible? And the answer is no. What one needs to show is that whatever that lesion is, it had an effect on the defendant's rationality, broadly speaking, which is the sort of fundamental responsibility concern in the law. And mostly, as my colleague Francis Shen has argued, it's being used rhetorically. In other words, you show a picture. So may I tell an anecdote?
yes, sure.
I was teaching a bunch of federal judges the case of Spider Siskoff. This is the very first contemporary neurolaw case from the early 1990s. This man killed his wife. He had no other history of violence or anything unremarkable. He was an upper middle class businessman, semi-retired at that point, in his 60s, never done a thing. It turns out he had a subarachnoid cyst pressing on his left frontal cortex. All right. There was absolutely nothing in his behavior and nothing in his history and nothing that we know about the effect of subarachnoid cysts that would suggest his rational capacities were in any way impaired. Nothing. So at the end of the presentation, these federal judges all voted 100% to convict him and to reject an insanity offense based on his cyst. The argument was he wasn't able to control himself, which in New York was then and still is a criterion for legal non-responsibility in the insanity offense. So then I asked these judges, all of whom had voted to convict, I said, how many of you would take into account the cyst at sentencing? And about a third raised their hand. And so I started calling on them. I said, why? And they said, well, he's got a hole in his head. I said, with all due respect, Your Honors, a hole in the head is not a legal excuse. Was there any evidence that his rationality was impaired? Was there any evidence that his self-control generally was impaired? And the answer to that was none, which is why they convicted. And not one of them could come up with an explanation except the complete non sequitur, he had a hole in his head. So that was, if they had taken it into account, it would have been the rhetorical use of the image as opposed to the genuine relevance. Now, I said there's another area where neuroscience arguably has made a difference, and that's in a trilogy of juvenile law cases decided by the Supreme Court between 2005 and 2012, all of which had to do with what kinds of punishments can you impose on very serious juvenile offenders. In the first case, Roper against Simmons, the question simply was, if someone had committed capital murder when they were 16 or 17, could you put them to death? The previous law said you could put them to death. There had been a previous case in the Supreme Court that said under 16, you couldn't put people to death. Under 16, people were not responsible enough. Even if they were responsible enough to be criminally responsible, they weren't responsible enough to deserve the worst penalty. All right, so now the question was, could you give the death penalty to 16 and 17-year-olds? Well, many of the amicus, friend of the court briefs by professional organizations, psychiatrists, pediatricians, and the like, suggested that they ought to be focusing on the neuroscience of brain development, which suggests that the biological development of the brain does not stop at age 18, which in general is the age of responsibility as an adult in the United States. Instead, what these data seem to show is that the brain keeps biologically maturing until the mid-20s on average. Some people a little younger, some people a little older. And everything I'm saying now is on average. Obviously, there are going to be 16-year-olds who look like 20-year-olds, and there are going to be 20-year-olds who look like 16-year-olds. But on average, the brain keeps maturing. Well, in the event, the Supreme Court did not cite the advocates for the use of neuroscience, keep citing and saying the Supreme Court used the neuroscience. It didn't. It didn't cite it. It cited behavioral psychology, developmental adolescent psychology, and by the way, very good behavioral psychology, to suggest that psychosocial development wasn't finished at 18 either. It also continued. Now, I just might point out as a digression, that's an argument that proves a bit too much, because psychosocial maturity keeps going on through the rest of your life. I'd like to believe, I'm now 80, I'd like to believe that I'm now more psychosocially mature than I was 10 years ago, but who knows? In any case, they did cite the behavioral science, and that was fine, because that was the relevant science. Because the question for the law is not what the adolescent's brain looks like. The question is what the adolescent's behavior looks like, because the legal criteria for responsibility are all behavioral. They are not neural. So, Supreme Court didn't cite it. But then in the next case, the question was, could you give juveniles life without the possibility of parole for non-homicide crimes? A couple of states did that. Things like rape, especially child rape, aggravated assault, things like that, which adults could get life without the possibility of parole. And the Supreme Court said no, and there they cited neuroscience, but no specific neuroscience. They just cited it generally. And as one Supreme Court justice said to me in an aside, I won't say who it is, this justice said, it was just make weight. They didn't need it at all. All right, then that was 2010. Then in 2012, they had to decide whether if a juvenile committed a homicide crime, you could give them life without the possibility of parole. And here the Supreme Court actually stepped back a bit. And they said, no, you can't give it mandatorily, which you could for an adult, but you can give it for the kids that are the worst of the worst. but you have to have a searching examination. Now, I recently testified before the United States Sentencing Commission. This is a federal agency that develops the rules called the guidelines for all federal criminal sentencing. And the question was, given everything we've learned recently about adolescents behaviorally and neurally, should we be giving them more of a break? And I said, there was nothing in the science that suggests they need to have a break or not. Either way, it's a moral and legal question. When do kids, on average, have enough of the right stuff that we can treat them like adults? And that's a sort of behavioral, moral, social, and ultimately legal question. And I said, when I look at the neuroscience, it would be consistent with, making the age of juvenile responsibility 16. It would make 25. I mean, there's nothing about the science that dictates where to draw that line. That's for society to decide. And the neuroscience is not going to decide it for you.
Yeah, interesting. Thank you so much. It was
those two, death penalty proceedings and juvenile sentencing, are the two major areas. There are now 7 now, or 8 international studies. They all have methodological problems that look at where neuroscience is being used in the courtroom. It's not being used very much anywhere. And interestingly enough, where it's being used, sometimes it's based on a complete lack of understanding. So, for example, in the Netherlands, neuroscience, scanning is being used to help decide if people are competent. Well, that's bizarre. Competence is a real world, present day evaluation of what kinds of capacities the person has. It's entirely behavioral. And the scan is not going to add anything to a careful behavioral evaluation. I don't know what they think they're learning. I mean, if the brain looks terrible, but the person acts normally, for legal purposes, they're normal. If the brain looks normal, but the person looks quite abnormal, irrational, psychotic, and as long as there's no question about malingering, and by the way, neuroscience cannot identify malingerers, but as long as we don't think someone's malingering, and if they have a life history consistent with psychosis, et cetera, then I don't care how good the brain looks. That person's a psychotic person and deserves to be treated accordingly under the law.
Thank you. I will come back to those edge cases or some of the psychotic people as well. But I think, let me ask you this question because it relates to the psychology you discussed as well as the intuition. You have stated that the legal concepts like intent and rationality, as you mentioned partly as well, rooted in the folk psychology. This is the term that you use. And even in determinism is true, like as we discussed in the neuroscience, some argue that the word is deterministic. Most individuals remain accountable. You covered part of this right now, unless a specific excusing condition are met. Can you explain how this folk psychology that you discussed, or our intuition about the justice or fairness, can be trusted for such task? Do we use this same intuition in other areas of our lives, especially in our modern and complicated society? How this is being covered?
Well, with all due respect, people like Greg Caruso, Dirk Verboom, and Robert Sapolsky, brilliant as they are, they sit in their armchair and they do very, very excellent, detailed analysis, but they're sitting in their armchair and they're doing a detailed analysis about allegedly the relation of determinism to responsibility that has real world consequences. Now, on the other hand, I don't know enough about the Iranian system to do anything comparative, but I know a lot about Western legal systems generally, and at least in Anglo-American law, we've got let's call it a 1,000-year history of the law developing in light of changing scientific understanding, changing social mores, changing socioeconomic conditions. It's really been a trial and error learned by experience. And what we've got now is a system, imperfect as it is, that really works quite well. Very well, I would add. I'm a great believer in the common law. That's the law that's created by courts over time. And even now in the era of statutes, and as you probably know on the continent, most of law is statutes, but these need to be interpreted. They're in words, and words require interpretation. So courts are always doing interpretive things. I believe over time, we've been getting it right. And the concept of the person, and the concept of intent, and the concept of rationality, in the common sense meaning of rationality. I'm not talking about perfect rationality, such as you might find in a department of economics or neuroscience or whatever. I'm talking about everyday, ordinary rationality as we all understand it and deal with it in everyday life. It's been with us forever. And folk psychology, which people like Greg and Dirk and Robert try to make into sort of dirty words, I think folk psychology is wonderful. In fact, let's test it out. So let me ask you, Dr. Shafa, why are you on this podcast today? Tell me why.
So one of the first reasons I started this podcast is to induce some changes in the opinion of the Iranians that increase the rational thinking, scientific thinking, and make changes in the society. That's my initial intention. I'm not sure how successful I have been, but that was the intention, to make changes in the opinion of the Iranians.
Okay. So let me flesh that out a little bit for you. And if you object, just interrupt me and tell me I'm wrong. So you desire to help make the Iranian people more scientifically literate, if you will. And I take it, I think there was a hidden premise there. You believe that if you do a good job with these podcasts, it might achieve that goal. And therefore you form the intent to do this series of podcasts. And if we can get a little bit more fine-grained now, why are you on this podcast today? Because you have the same general desire. You believe talking to me might help achieve that goal. And you form the intent to have this conversation. And now let's turn it around on me. I desire to help educate the public. It's one of the things I do as a professor. I believe that by talking to a very well-educated person like yourself and the boss, I can perhaps achieve that goal. And here I am. Now notice, you're a biological scientist, and although I'm a psychologist as well as a lawyer, I'm not a biologist. And by the way, I'm not a philosopher either, although I am a fellow traveler. Notice neither of us cited a biological variable in our story. I mean, what did we treat each other as? We treated each other as folk psychological agents. That is, as agents whose mental states, in part, and I want to underline 47 times, in part, whose mental states in part explain, and I mean genuinely explain, in the way we scientists talk about explanation, genuinely explain behavior. Now, of course, there are going to be biological variables. You know, my brain's got to be alive. My brain's dead, I'm dead, and I'll have no interest to you whatsoever. And there are going to be sociological variables that are affecting us. I mean, there's a whole causal story. This is not, I mean, I'm a great believer in physicalism plus causal closure. This is not a sort of random
metaphysical.
Yeah. I don't talk about determinism much anymore. I prefer physicalism and causal closure. I think, more accurate, because no one, I mean, there are so many different meanings of determinism. But in any case, we're all folk psychological creatures, and it's impossible for us to imagine human interaction, human society, without folk psychology. I mean, neurons, even the connectome, does not have a sense of past, present, and future. Neurons, even the connectome, doesn't have aspirations. It doesn't care about anything. These are properties of people. We have aspirations. We, as people, as agents, have a sense of past, present, and future, etc., etc. So, folk psychology to me is not a dirty word. It's a absolutely accurate descriptor of the 8 billion creatures I know about who walk the face of this earth. God bless them, every one of them. And folks, here's what I think about the mind-body problem, as it were. This is going to be so superficial, it's going to be breathtaking. Until we solve the biology of how the brain enables the mind, generally, consciousness, which, as you know, David Chalmers calls the hardest problem, intentionality, until we figure that out, we're never going to know the answer to the metaphysical question. And even then, we're not going to be sure about the answer to the metaphysical question, because to understand how we really are, we'd have to step outside the universe and look in. And even people like Sapolsky, Caruso, and Perboom can't do that. Not yet.
Yes, very, very interesting. So I have some questions about the intent, because there are some arguments that Sapolsky or similar people brings, that how that intention comes. So I think they look at the history, but I leave it for later. So Abbas, please go ahead and ask your question.
Thank you for the opportunity. Professor Morse, you made a distinction between the scientific understanding of a behavior and what part of that behavior, or what description of that behavior, or what understanding of that behavior means for law. So there's a separation between these two. So if we take a step back further, in your understanding, what is the basic purpose or function of our criminal or justice system? Serving justice or resolving conflicts? In other words, are there any metaphysical basis for the need for the legal system, these legal systems, or only there are just practical or pragmatic needs or considerations?
Well, that's a very good question. I think it's a question of historical anthropology that I would say I am not capable of answering properly. But here's what I can say. When I look at Anglo-American and continental justice, basically it has criminal justice. It has two main goals. One is to do retributive justice, that is to give people what they deserve. Now, people often rebel against people deserving anything. But interestingly enough, there are notions of desert in theories of contract law, property law. There are notions of desert throughout the law. But it's not the only explanation, but it is a persistent and fundamental view, and has been for a very long time, that one of the goals of the criminal justice system is to give people what they deserve. Now, interestingly enough, if you ask people to rank order the seriousness of harms they can cause to other people, worldwide, there's enormous agreement about what is more serious than what. You know, the ordinal ranking is exceptional inter-rater reliability worldwide. But how much people should get for what, there's huge dispute. And I do not believe there's a tablet in the sky that tells us what is the appropriate penalty for any particular crime. To me, that is a social, moral question and ultimately a legal question that the legislature must decide. Contrasted with retributive desert justice is consequential justice, deterring people, incapacitating dangerous people, etc., etc. But notice, what desert does for us is it puts a limit on our ability to infringe on people's freedom for the safety of us all. If all we cared about is who's dangerous, then we could move to the public health quarantine model of somebody like Greg Caruso. The problem is we're going to be infringing on people's freedoms, forget our ability to make correct predictions and the ability to do anything to help these people. Forget that for a moment. We're going to be infringing on people's freedoms when they don't deserve to have their freedom infringed on. Now, interestingly enough, there's a new novel by an American novelist named Lila Lalami. It's called Dream Hotel. Are you both aware of it?
I think it might be Iranian writer, yes. Leila, I am not sure Arabian or Iranian. No, I'm not familiar.
With African, but in background. Lila Lalami, called Dream Hotel. And in this potential universe in the future, we've developed the ability to record people's dreams. And from their dreams, we make predictions in this fictional universe of who's going to be dangerous. And so the protagonist is locked up. And it's a horror story. And that is what we would have. Now, people often think that American criminal justice, and by the way, all Western criminal justice is not as harsh as the Americans. The Scandinavians, for instance, are very, very mild in their punishments compared to the Americans. But people think that it's retributive justice, the desire for vengeance, that causes American criminal justice to be harsh. That's false. First of all, vengeance is not retributive justice. Vengeance is a theory of bloodlust. It has nothing to do with justice. Retributive justice is a theory of desert, of what people deserve. And it's desert that puts a limit on the harsh things we can do to people. In fact, the worst excesses in American criminal justice have all been attributed to consequential reasoning about deterrence and incapacitation of the sort that drives people like Robert Sapolsky and Dirk Boom and Greg Caruso. So in fact, I'm the softie here. I'm the soft-headed guy because I'm a mixed theorist. I believe retributivism sets a floor and sets a cap. I don't believe, as I said, there's any tablet in the sky that tells us what the right punishment is, but the legislature will set a range for most crimes. And within that range, we can take both desert and, let me just say, dangerousness into account. And I think that's the best positive explanation of the American criminal justice system. It's certainly the position the Supreme Court has adopted. Now, every time we have an Eighth Amendment cruel and unusual punishment case, they talk about the primary goals of punishment being retributivism, deterrence, and incapacitation. And I think that's right as a matter of positive law, and I think it's normatively right. It's a good system.
Great, thank you. After talking about this distinction about the scientific category and legal category, in your work, you talk about intentional actions and take that as a base for legal responsibility. Could you elaborate on this action guiding model in your work and why you believe it should hold, how this would hold in a deterministic world?
Okay. To begin, I don't think there's any conflict between the scientific worldview and the legal worldview, because I think the legal worldview is perfectly consistent with the science of psychology as we know it today, which is not to say we may not learn things in the future about certain conditions. Dr. Shafa previously referred to addiction. Maybe our laws should change on addiction and things like that. And that's something I know a lot about, so I'd be happy to talk about that later. But there's no necessary conflict. But you're absolutely right that the law says what we are doing is treating people as agents, the kinds of intentional agents who can be guided by the legal rules. In other words, if we think about what law is a series, and now I'm going to be very, again, superficial, but good enough for government work. It's a series of rules that's meant to guide behavior. And by the way, it's not different in that respect from etiquette, social norms, moral norms generally. These are all action guiding ways that human beings have learned to order their lives together, their social interpersonal lives together. What's different about the law is it tends to be very specific, and most importantly, it's backed up by the power of the state. If I treat you incredibly rudely today, the worst thing that would happen to me is you'd say, Morse, you're a cad, and cut off the podcast. But, if I do something that's criminal, the constable can certainly arrest it. And that's a big difference. But in principle, they're all the same. Now, what kinds of creatures can be guided by these rules? Now, go back to the question I asked Dr. Shafa earlier on about why are we having this conversation today. These are folk psychological creatures. So what kind of creature can use rules to guide their behavior? Because what does law do? It tells us what we must do, what we can do, what we cannot do, and it tells us what will happen if we don't comply. Well, look, young children are intentional. They do things on purpose, just like adults do. But we don't hold them fully responsible. Why not? Because we think as a matter of developmental immaturity, they're not yet fully rational. And we think as they develop through the stages of late childhood and adolescence, they become more and more rational. We don't think they become more and more responsible because they get taller or because determinism has more of a grip on them when they're 17 or when they're 5 than when they're 18 or anything of the sort. It's a rationality decision. Do they have enough of the right stuff? And if you think about all the excusing conditions, they're rationality problems. Think about the classes of people that we tend to think, at least prima facie, ought to be excused. Infants, as a matter of developmental immaturity. People with severe mental disorders, at least some of them. And what's wrong with those people? Their rationality is impaired. We don't understand the causes of most mental disorders, and we have very, very imperfect tools for treating it today. But we've understood forever that there are people who are out of touch with reality, and it seems no fault of their own. People with intellectual disability, what used to be called retardation. People with dementias. What do they all have in common? Their capacity for rationality, and for those who like a control test for self-regulation, is impaired through no fault of their own. And that's why we excuse them. It has nothing to do with determinism. It has nothing to do with causation. All behavior all the time is caused. Causation is not per se an excusing condition. If it were, no one would ever be responsible for anything. Now, that's music to the ears of Robert Sapolsky and Greg Caruso and Dirk Perigel. And you ask, what would the deterministic system look like? Well, in his book, and my co-teacher and I taught Greg's Rejecting Retributivism 2 years ago, which, by the way, my students hated. They thought he was just so wrong and so dangerous. And not because we were brainwashing them, right? They're a product of, their times and place as well. It wouldn't be a criminal justice system. I mean, the whole idea of talking about a crime is a notion infused with moral notions. A crime is a moral wrong. Now, some crimes, perhaps not, regulatory crimes and the like. But even then, if you know it's against the law, arguably it's a moral violation to violate it, even if behavior itself is not immoral. But at the core of the criminal law, force, fraud, and theft, which is what everyone's worried about. Greg Caruso is not worried about truckers in interstate commerce putting the right labels on their foodstuffs or something of the sort. He's worried about force, fraud, and theft, as we are all. And there would be no moral notion that anyone had done anything wrong. It would only be a notion of, are they dangerous? Now, in that world, notice, why would they have to do something that we think is, let me just say, dangerous to other people to be clutched and perhaps manipulated or treated or incarcerated, even if it's in a pleasant place, quote unquote? I mean, it's just a matter of evidence. If we could be as sure about future dangerousness without a wrong or a dangerous act, what would be the reason not to lock them up if we could predict they were going to be dangerous and to treat them? And, at this point, as I said, this is an armchair universe. It's never been tried everywhere, as opposed to 1,000 years of Western legal history, which has been tried. And as I said earlier, it's doing pretty well. Really imperfect. And I should just add here, I'm a big internal law reformer. I want to do lots of reforms internally. But what Greg and Robert and Dirk want to do is they want to abolish it entirely. It's an external critique. And I just think it would be a very dangerous world. So, what do we do in a world, let's just say democracies for a moment, small d? We vote. And if I have to vote between Caruso world or the world we have, I can assure you I want to be in my world and not Caruso world. And as you probably know, there's some behavioral science evidence that was done by Thayer and Gachter that show that people are sort of inherent retributivists. And moreover, when German students had a choice between being in a punishment or a non-punishment society, virtually all opted to be in a non-punishment society, but there was a condition. They could emigrate. And within no time, they all emigrated to the punishment side because, we're never going to get rid of free riding, ever.
I think, Professor Morse, that's punishment or the retribution. I was reading some papers as well. I think it's deep-rooted in our evolution as well. So if you look at the biology, so this is something that intuitionally is also deep wired maybe in some part of genes or brains that is hard to overcome, which is, I think, is unfortunate, at least my opinion. But I think this is what it is. It's a reality here.
Well, it's interesting. There's a very, very good paper published by an Ohio State philosopher back in 1988 in the Journal of Philosophy, which is our best general philosophical journal in the United States. His name is Andrew Oldenquist, Oldenquist. Do I need to do that again, boss? Or you got
You can write and we can share and look at it.
Yeah.
All right. It's a justification of retribution. And basically he takes your position, Dr. Shafa. He says, this essentially came out of a lot of deep-rooted social practices that probably had, an evolutionary psychological history. But over time, it got cleaned up. And it became a theory of justice as opposed to just a bloodlust, justification. Now, here's an interesting thing for the consequentialists, like people like Pereboom or Sapolsky or Caruso. They say we should be consequentialists. I put in that camp, by the way, also Joshua Green, and Jonathan Cohen. They say the good, what we should be doing is maximizing the good. Well, they sound like deontologists because they're saying there is a true right goal. So they're really deontologists too. By the way, I don't have that insight on my own. I get that from a professor of jurisprudence and law at Zurich named Matthias Mahlman, who's written a brilliant book recently on minds and rights. Also, Mahlmann, really worth reading. Deep. Anyhow, so I think, yes, you're right. There are evolutionary roots. There are evolutionary roots to everything. Interestingly enough, a very well-known neuroscience at Trinity College Dublin whose name is now escaping me for a minute, has just written a book on why we are, and it's an attempt to show biologically, starting with the single-cell organism, why we can be free agents. Free agency is in the title of the book.
Produced by Kevin Mitchell, I think.
Kevin Mitchell, that's right. Very good. And I'm especially ashamed that I don't remember, because I just taught that book with my co-teacher in my seminar this past year.
That book is published at the same time that Determin published, and I'm asking to have an interview with him. Unfortunately, it hasn't been successful yet, but that book is also get translated in Farsi, so
good.
Iranians will be access to this book as well.
Yeah, his problem, much like I think the problem of Sapolsky, is insufficient training in philosophy. I mean, Greg Caruso is a very good trained philosopher, as is Dirk Pereboom. They're both very good at what they do. And I think their work is, to me, more helpful, although no one writes as charmingly as Robert Sapolsky. He just seduces you in. There's no one like him.
Exactly. So I think, Professor Morse, before Abbas, you go to the next question, something came to my mind I can ask here. So, so I think let's remember the late Bruce Waller as well. Bruce Waller was a philosopher that passed away recently. He argues that we have free will, but he wanted to ruin the moral responsibilities and still keeping some of the punishment, some part of it that cause maybe prevention, or is toward more Caruso's philosophy. But he sees himself to ruin the moral responsibility. I have a question. He argues, or some argument right now, that the criminal justice is now so strong that is like facing the basis of its roots, which is the moral responsibility. Even the moral responsibility is being shaken by some of the neuroscience findings or some of the findings of even psychology, but still criminal justice is protecting himself about these findings. So what's your answer to this kind of argument that moral responsibilities get weakened even by philosophical arguments, not only by neuroscience, but still the criminal justice is defending himself and it stays very stronger than the roots of itself, because the criminal justice has been made gradually during a few hundred years based on the moral responsibility. Now the moral responsibility is get weakened, but still the criminal system is very strong.
I think that's just entirely wrong.
Okay.
Number one, I think we still think moral responsibility is crucial because we still have all the classic excuses that go to moral responsibility. I'm, as I said, a reformer in this area. I've argued for a generic partial responsibility mitigating condition. I've gotten a lot of attention in scholarly literature, got no attention by the legislatures, which is too bad. But the law clearly still takes moral responsibility very seriously. And there is such a rich legal literature in the law reviews and elsewhere in the United States that and legal scholarship has become vastly more interdisciplinary than when I started law teaching. When I started law teaching, that was 1974, people looked at me like I was a Martian. I had a Ph.D. in psychology. What was that about? I mean, how could that have anything to do with law?
Law.
Well, I got lucky because everyone thought then that psychology was going to be the major interdiscipline that would help shape the law, because that's when interdisciplinary studies in law took off. It turns out that philosophy and economics, I would say, are the two most important interdisciplines, although psychology still. So law professors basically inhale these literatures because they think it will help them, power their normative arguments for what the legal system should be like. And especially on the defense side in criminal law, they believe these neuroscientific findings were going to revolutionize our concept of the person, revolutionize our excusing conditions and the like. And nothing of the sort has happened. Now, here's something. Now, this is going to be, I don't know your background, boss. I assume you're a philosopher. Is that right?
No, I'm actually part engineer, part musician.
Oh, well, half of you is great. I won't say which. Well, the engineer part of you is certainly a rational thinker. Not that music isn't rational. It is, of course. As we look at the number of studies where law professors in their scholarship or other commentators in scholarship have used the findings of behavioral neuroscience to support their typically defense-oriented arguments, if you look, I would say the curve of productivity looks just like the curve of productivity of fMRI studies. Now, as you both probably know, fMRI, the magnets became freely available for behavioral research, non-clinical behavioral research in psychology departments, neuroscience departments, and the like, let's say starting in 2000. And as the magnets got cheaper and everyone needed to have one, what you saw is an enormous increase, a logarithmic increase in the number of articles in behavioral neuroscience. And I would say, just looking at the databases of published articles, and there's a whole website devoted to law and neuroscience now in the United States, SSRN it's called. There's SSRN in the sciences too, but in law also. I would say the same thing was true of legal articles that use the neuroscience. What I've noticed is in the last couple of years, there were fewer and fewer of these legal articles that use basic behavioral neuroscience to support their arguments. And I think the reason is because the promise of neuroscience has not panned out. It hasn't, as it were, cashed the IOU yet. In 2002, The Economist newspaper in England, as we would say in the United States, The Economist magazine, they say newspaper. The Economist had this lovely editorial that said, everyone's afraid that genetics, the genome had just been cracked. Everyone says genetics is going to basically transform the human self and human existence, but neuroscience is going to do those things first. That was 2002. It ain't happened, and it ain't gonna happen. Not in my lifetime, and I'm really old. You guys are middle-aged. Not in your lifetime either. Thank goodness, because you don't want to live in that world. And you know what? Greg doesn't either, I believe, his heart of hearts.
Okay, thank you. So I think this brings the next question that Abbas may ask about this kind of findings you call brain overclaim syndrome. Maybe Abbas, go ahead about this.
You work with a lovely phrase, brain overclaim syndrome, and we heard about it from you. So, what role do you think neuroscience and scientific understanding of our world in general should play or can play in our legal system or our understanding of law or our reforming it?
Yes, absolutely. I'm not one of the complete skeptics who thinks it's a category mistake to think that neuroscience or, let's say, behavioral genetics, for another example, are completely irrelevant to law. But you've always got to ask two questions anytime someone wants to use any science to either reform the law generally or to guide individual case decision making. First of all, is the science good science? And for my purposes, I'm going to assume that any neuroscience is decently good neuroscience. Although what we've learned is, like all new sciences, behavioral neuroscience was filled with artifacts in the early years that are only now being learned to control for. So a lot of the early findings that look very powerful don't look so powerful today. But to their credit, the neuroscientists have cleaned up their act, and they've tried to get better and better at spotting these artifacts and controlling for them. I'll give you one example. There's not much data mining anymore. It used to be you had a hypothesis, you collected your data, it didn't support your hypothesis, but you found something else. So you reported to something else. Now you have to basically pre-register your methodology, your hypothesis, and all that. That's the state of the art today. And that's a real advance, as are a lot of the statistical techniques we now use to analyze that. But assuming the science is good, then the question is, what's the legal relevance? What you have to show, no claiming, he's got a hole in his head, therefore he's less responsible. You've got to show how whatever the neuroscience finding is actually affects a legal policy or a legal case. That's what you have to show. And you can't just wave your hand. You can't beg the question. You have to show how it's relevant precisely. Now, sometimes it's not going to be obvious precisely how, but then it requires a bridge argument to show that here's how I got to the legal relevance from this basic finding. Here's my, it's a little bit like when you're doing math in grade school. The teacher always says, show your work. Well, what I say to experts who want to testify is, what's your bridge argument to show that this is legally relevant? So I gave you an example before from the Netherlands of using fMRI scans to help decide cases of present competence, criminal competence. I mean, it's just no argument. I mean, it's basically he's got a hole in his head once again, and that's not good enough. I mean, so in the United States, let me give you an example, a very specific example. It's a little bit abstract. To be competent to stand trial, which is a separate issue from whether you're responsible at the time of the crime. Competence to stand trial is basically a requirement of due process in the United States. A criminal defendant may not be tried, full stop, unless that defendant is competent. And what does competence mean in the United States? Well, as you know, we have basically 51 jurisdictions, 50 states plus the feds. But the basic idea is the defendant has sufficient rational capacity to understand the charges and the proceedings, and has sufficient rational understanding to be able to assist his counsel. Now, what you've got to do is you've got to evaluate the defendant behaviorally. What does the defendant know? What does the defendant understand? What is he capable of understanding if you give him more information, for example? How is a brain scan going to help you? I mean, let's assume you find a lesion. What does that tell you about his behavior? Now, if the lesion and the behavior are really well tied together by clinical observation and good studies, then we're more secure maybe in our judgment that the person is not competent. But except for that case, and that's going to be an extreme case where the behavior is going to be obvious anyhow, because the standard for competence in the United States, much like the standard for responsibility, is actually not high. Now, notice that is a moral question. How high should the standard be for competence or for moral responsibility? If you're a tough guy, you don't have to have that much capacity. If you're a tender person, you're going to require more. That's not a scientific question, ultimately. I mean, what science may tell us is about human capacities in general, but it can't tell us where to draw the line. Just like the question of adult responsibility compared to juveniles.
Yes, that's great. I think let's Abbas go ahead.
Yeah, I have a question about this standard for competence. Professor Sapolsky cites three criteria. Is the person, accused person, did know about his result of his action? Did he know he could have done otherwise? And did he have time for choosing his action? And he says these are questions about free will. But I want to be sure that I understand you well. I think you are making the exact same criteria, but for competence, not free will.
No.
All right?
No, that's not right. If Sapolsky was talking about competence when he developed those three criteria, the first, I suppose, is a competence criteria. But remember, you wouldn't be able to understand the charges and proceedings unless you knew what you allegedly had done. And you wouldn't be able to assist counsel unless you know what you had done and you could advise counsel about the facts of the case and stuff like that. So that's a competence question. But the other questions are generally moral and legal responsibility questions. And he asked them as free will questions. I don't. I ask them because free will is not a criterion in law. Full stop. The prosecution never has to prove that the defendant had free will, and the defendant never has to establish that he didn't have free will. The criteria, in this metaphysical sense, the criteria for responsibility are all acts and mental states, 100%. Now, when we ask, could a person do other? Notice that bears a common sense meaning and it bears a metaphysical meaning. Sapolsky wants to go metaphysical. He wants to say if something like determinism or something quite like it is true, then no one could ever have done other than what they did in a metaphysical sense. But that's not the law's question. Maybe it should be. Robert Sapolsky thinks it should be. But it's not the law's question. The law's question is this. Let me give you an example. You're not in the same place, you and Dr. Shafa, are you?
No, I'm
in Iran.
He's in Iran.
Oh, that's right. Of course. May I assume, hypothetically, you're sitting next to each other. Now, excuse me for being very rude to both of you. I now, because all Americans are armed, we know that, I take out my gun and I hold it at your head of us. And I say, kill Dr. Shafa or I'll kill you. Now, you've got a very hard choice. I mean, Dr. Shafa is innocent and you're innocent. It's one innocent life is going to be taken. Should it be yours or should it be Dr. Shafa's? And you've got to choose. Now, let's assume you choose to save your own life. Now, did you kill Dr. Shafa intentionally? Of course you did. I mean, you desired to live. You believed that if you succumbed to my threat and killed him, you would live. So you formed the intention to kill Dr. Shafa, and you did. Should you be guilty of murder, or should you be excused? Now, what's your claim? Your claim is not that you don't have metaphysical free will. Here's what your claim is in law. Through no fault of my own, I was placed in a situation where I faced such a hard choice. Do it or else. Kill him or I'll kill you. That only a saint would resist the threat. And we can't expect people to be saints. So we say you were coerced. I mean, the technical name for the defense in Anglo-American law is duress. But it has nothing to do with metaphysical free will. It has to do with a threat, a hard choice. Now, what if that hard choice, as it were, comes from within? Let's think about the addict. No one's holding a gun to their head when they use, but they say, my internal desire was so strong that I couldn't help myself. That, in other words, the accelerator was pressed to the floor and the brake was broken, and therefore I'm not responsible. Well, maybe in some cases. I think the scientific evidence, including the neuroscientific evidence, by the way, suggests that conclusion is false. But let's assume it's true, that someone lacks internal self-regulation to such an extent that we cannot ask them to behave themselves. They lack the capacity to do so. Well, should that be an excusing condition? And I think at the extreme, sure, it should be. Now, it's not in most states in the United States. I'm an opponent of control tests, as it were, because I think most people who have a control defect, we will find that it's a rationality defect. When their desire is so strong, they can't think straight. Once upon a time in my career, I was a practicing psychotherapist. And I dealt with people who had substance problems. And I'm now using metaphors that they use. They would say, the desire was like a buzzing in my ears that I couldn't get out of my head, or a song I couldn't get out of my head. And I couldn't think of anything else except satisfying the desire. Well, again, I think the best way to explain those cases is, in some cases, extreme desire will obliterate the capacity for rational thinking. But the question is, if you're an addict, don't you know that's going to happen ahead of time? And isn't it up to you to take steps not to be in that position? Go for treatment. Take opiate antagonists or whatever it is. If you have a stimulant problem, enter a contingency management program. So that's called the theory of diachronous responsibility. Even though at the moment you may not be responsible, in a certain sense, you're responsible for being in that condition. I mean, the best example, it's a famous American case of a gentleman who knew he had epilepsy. Now, we don't know enough about this case, but let's assume he knew he had epilepsy and it wasn't yet completely controlled by medication. He went driving, and let's assume against doctor's orders. And while driving, he blacked out. He went ictal. He had a seizure. Mm-hmm. And he rode, the Buick he was driving went up on the sidewalk and killed 4 people. When that happened, he wasn't acting at all. He was not an intentional actor. He was in the midst of a seizure. But he knew he was at risk of that sort of thing. when he left the driveway. And so therefore we could maybe hold him guilty of some kind of risk creation homicide, because he was guilty of driving that car, because he had all his marbles about him when he went driving. So again, Robert's critique is an external critique. He just wants to get rid of responsibility and therefore criminal justice altogether. I mean, he doesn't have, to Greg Caruso's credit, he's the only person in his camp that I know about that has had the courage to put forth a fully developed proposal for what the world would look like if his ideas were adopted. And I give him all the credit in the world for that, because that's a very perilous enterprise to create a whole new world. Shall we say a brave new world?
Exactly.
It's an ugly world. I think so, but there it is.
I think one of the arguments that the people against ruining the free will or the moral responsibility is what you mentioned, is the consequence. We have to have like a replacement for that. So I think Greg Caruso developed his public health quarantine model. At least he has something in place that he's defending that, and I think he has wrote about that, and he's writing a new book right now about the world without free will. I think he had enough arguments to defend his idea, but I think maybe it needs more evidence and maybe needs some time. So I think before I go to Abbas for the last two questions, I think we have only 10 minutes. So I think you are right, maybe, but the argument against, I think I'm talking for Sapolsky right now. So they are seeing, for example, a tumor in the prefrontal cortex, and they can relate that to a behavior that caused an impulsion or caused an attack or a killing, or the epilepsy as well. But what Sapolsky, you know better than me, saying that we see here a connection between the tumor to the action or the behavior, but in other cases, in the normal human, there are millions of these wires that goes from the from the source to the action that we don't know all, but they are there. But still, the person is not responsible because we cannot control all of those wires that cause the behavior. But I think your opinion is not like this.
No, of course not. Who, of course, can control all the neural circuits? What are they?
Yeah.
10 to the 15th circuits?
Yeah.
Imagine, imagine being able to control all those circuits on an individual basis. Look, the main case that came up was published, I think, in 2002 by a neurologist and a neurosurgeon at the University of Virginia, of a man who had a prefrontal tumor, and right above the supraorbital ridge. So I call him Mr. Orft, real frontal tumor, who was a perfectly normal guy. And then all of a sudden he started molesting his stepdaughter and downloading child pornography. I'm sure you know about the case.
Yes.
And ultimately the tumor was resected and he was absolutely fine, went home again, had no interest in children and all that. He looked neurologically fine. 8 months later, headache and interest in children are back. The tumor's back. So now we know, because of the time series analysis, no tumor, no interest in children. But all adults who have interests in children are not responsible for those interests. All of them. I mean, who chooses to be a pedophile? When you discover what your sexuality is in your teens, you look at a list of a zillion possible sex objects, shoes, goats, adult human beings. Well, I think I'll be a pedophile. No one does that. You just discover what you are. You're not responsible for it. He acted on it. And the question is he responsible for acting on it? And here's the way I teach that case. When he first touched his stepdaughter, he clearly, despite the orbital frontal tumor, which was, by the way, a very fast-growing, non-metastatic tumor of the soft blood vessels, and in a spot that often is associated with antisocial behavior. When he first molested his stepdaughter, he clearly had lots of rational and control capacity. Over time, I think that tumor affected his rational control capacity. So towards the end, when they finally discovered he had the tumor, clearly he was not a responsible agent. But notice that we could have made the same analysis if we knew nothing about the tumor. And until MRI, we would have known nothing about the tumor because it's soft tissue and X-ray wouldn't have shown up. X-ray would have only shown up if the tumor had eaten away some of the bone of the supraorbital ridge. That would be the only way. But what we could know is, for reasons we weren't sure of, here's a guy who has a major change of behavior, but who looks otherwise rational, who deteriorates in terms of his behavioral rationality over months and months until he's finally not a rational agent at all. And we could do that analysis without knowing anything about his brain. And so the question is, since he was guilty of assault crimes in the neurological consulting room, I would certainly let him off for those crimes. But for the initial crime of molesting his stepdaughter, I'm not sure because we don't have enough information. But conceivably, he was responsible. Now, that's a separate question from how dangerous he's going to be once you've taken the tumor away. Remember what I said before about retributivism? It sets a dessert and a cap.
Mm-hmm.
This is a guy who's not dangerous once you remove that tumor. So whatever is the minimum you can give this guy, I would give him the minimum.
Thank you, Professor Morse. I think, Pasco, for your question, I asked the last question afterwards.
Yeah, you talked about reforms in our criminal justice or justice system. What areas, in your view, needs the most urgent reforms right now?
Well, the first is the harshness of our sentencing laws. I think we put too many people in prison for too long. Now, when I say too many people for too long, 83% of the people in maximum security have committed serious crimes that even the most, committed progressive would have to agree deserve imprisonment. Basic force, fraud, theft crimes. The others are drug-related crimes, and we're not sure how many of those have actually been violent crimes pled to a lesser included offense. All right, so I think our penalties are far too long. And I would certainly get rid of the death penalty. So we waste a lot of time and effort. And I should say, just to be completely honest, I believe that some people deserve to die. I believe that the state has a right to kill them. But since I believe we're never going to do it fairly, it's always going to be unequally distributed. I don't want to do it at all. So get rid of the death penalty and make our sentences more lenient. Second of all, and I mentioned this before, I really have advocated strongly for having a partial responsibility mitigation that would lead to yet a fourth verdict beyond guilty, not guilty, and not guilty by reason of insanity. This would be guilty but partially responsible. These would be for people who have very substantial rationality, or if you prefer, self-control deficits, but not enough for a full excuse. Now, this gets taken into account at sentencing in the United States, but that's totally discretionary. The judge doesn't have to do it. I want them to have a claim that every defendant can raise at trial, because I think a lot of criminal justice defendants are substantially impaired, not fully, so they deserve to be convicted and punished, but they ought to have some kind of mitigating defense they can raise at trial. So those would be the two reforms I would focus on. And so
Thank you so much. Yeah, go ahead. No, go ahead, please.
No, I was going to say, my friends call it a punishment discount. My critics say I'm a terrible softie, but that's all right. I don't mind.
Yeah, thank you so much, Professor Morse. I have a question that is not related to these topics, and I forgot to send you this, but hopefully you can cover in a few minutes. It's a big discussion I know we can maybe discuss about this later, but this is some topics also going in Iran about the euthanasia, like assisted suicide, which I know in 7 or 8 states in US is legal, and I think in Pennsylvania is not legal, or some other jurisdictions. And also, I know, for example, Switzerland has other like a more liberal of this euthanasia. I know that's a big topic that hopefully we can cover with some other legal aspects. But at least from your opinion, because I'm not sure where you stand about this euthanasia, or you are supporting in the well-regulated. I've been not very liberal. I've been regulated by federal law or medical and also morality. So how do you interpret this? So are you for it, or you see totally against the assisted suicide through the medical assisted suicide? Sorry,
Well,
it's like a big question. Hopefully you can cover a few minutes. Yes.
Okay. As a matter of constitutional law, you are not entitled anywhere in the United States to physician-assisted suicide. But if the state wishes to adopt physician-assisted suicide, it may. So that basically raises the question of morality and public policy that our good question has raised. And obviously, there are enormous trade-offs. On the one hand, we want to allow competent people to die with dignity. On the other hand, we're afraid of all the abuses, and we're afraid that it will corrupt the ethics of the medical profession and things like that. So it's a very, very difficult question. We know that in some countries that have it, it seems to work pretty well, and there doesn't seem to be massive abuse of any sort. So I'm thinking of Netherlands, Belgium, Switzerland. Even in the United States, those states that have it typically have all sorts of real required protections. There has to be independent evaluations of the person's competence, of whether they are actually suffering from a terminal illness and the like. It's easy, I believe, to place enough procedural protections that if we were sure they would be followed out, that it would not be so dangerous. People wouldn't be abused. But human beings are imperfect creatures. So it strikes me as a very, very close question.
Yeah.
You know, I'd like to think for me, I would like to have the opportunity to be able to do it. But do I think the entire world should be geared towards people like me? No. Obviously, I'm not an average person. On the other hand, I'm not so special either. So where I ultimately come out is with enough protections, I wish a state would do it.
Thank you so much. So we will ask this question from Professor Martin Fisher as well after this. So we have in half an hour, we are going to talk to him. Yes, I will ask him as well, because he has some books and also opinion about the deaths as well. He is good philosophy around that. So I would like to know what he thinks as well. And also it's illegal in Iran as well. So it's like because the law in Iran is like combined with religion as well. So some of the religion is not prohibited, like killing in any way. But I think now the new generations are talking more freely about this. So as you talk about the dignity, human dignity and freedom to choose. So I wanted to ask you about this as a legal expert. Thank you so much, Professor Morse. Yes, go ahead.
I haven't seen Professor Fisher in over a decade, but I think the world of him. So please send him my warm regards.
Of course, I'm thinking maybe Professor Morse, I know how you're open to this because I arranged a kind of discussion between Professor Caruso and Sapolsky, as well as my uncle, who is a lawyer in New York, Dr. Irani, to discuss about different aspects of the free will and moral responsibility, as well as criminal justice, but they more in the same side. So I think the discussion was good, but I think if you are willing, maybe I would Professor Caruso is willing to accept, maybe I would like to maybe ask both of you, maybe you discuss different aspects of this, if you open to this.
I am open to it, but at this point, I find discussions about the metaphysical question of free will, frankly,
Okay.
kind of boring.
Okay.
Because we're not going to solve it. Now,
No, I know.
I'm not a professional philosopher, so there are no new moves I'm going to make. I mean,
Anyway.
like John Martin Fisher and Greg Caruso are professionals. They may make a move.
I know. I try maybe to see if they are open. I can ask both of
I'm
them.
happy to talk with Greg. He's a great guy.
Yeah, I think the reason you mentioned this as well is multidisciplinary right now. You're better than us, yeah. So I think neuroscience, law, psychology, biology, they are interchangeable. They are connected. So I think if a expert from the law stays with a professor, like in the biology, like Sapolsky even, or even the philosophers, maybe they can exchange ideas, and then it helps maybe our legal system as well. So anyway, if I can arrange, I will let you know. Let's see if I approach Professor Caruso and Sapolsky. If they are both okay, I can sit three of you together.
That would be great. So, Boss, Mehdi, thank you so much. This has been actually a very, very good interview. I do a lot of these things, and you guys are great.
Thank you so much, Professor Morse.
You too.
Thank you,
Goodbye.
Professor.
Thank you.
Thank you.
Bye.
Goodbye.